the allegations and, of course, counter allegations and reactions concerning the appeal court's verdict sacking the governor of Plateau State, where the Nigerian presidency having faulted those complaining over the judgment of the appeal court sacking Governor Mutfwang of Plateau State. Now, the president, a special advisor on information and strategy, Bayo Ononuga, said the People's Democratic Party, PDP, should be blamed for the sack of its governor and not the president or the judiciary. Of course, to shed more light on this, right now I am joined by legal practitioner Valerian, Nwadike, founder and managing partner, Valerian, Vianney and Partners LP. Thank you so much for your time, Valerian.
Thank you. Thank you very much.
All right, now, can you just let us know what you think concerning the appeal court's decision as regards the sacking of the governor on what some have considered pre-election and even post-election matters?
I want to start by stating that the decision of the Court of Appeal is the law as it is now, and aggrieved parties have the right of appeal to the Supreme Court. That having been said, from the facts available to me, the court mentioned primaries, PDP primaries, and lack of it. And from my understanding of the provisions of the Electoral Act, and also standing on the case of Wellington against PDP Supreme Court decision, Part 1893, their rules or their procedures or their guidelines regarding what can be brought in as election, post-election matter, and what can be brought in as pre-election matter. And from what I have seen so far, I've not seen the judgment of the court, but from the facts I've read on the news, it seems to be a pre-election matter, since it's talking about primaries. And if it is a pre-election matter, I'm afraid the Court of Appeal might not really have jurisdiction to hear things. But like I said, the decision of the court is the law as it is until the Supreme Court says otherwise. So there's no need for blame game. There's no need to blame anybody. The aggrieved parties know what to do, which is heading to the Supreme Court, which is the final court to give us the final verdict.
Most recent judgments, of course, of the Court of Appeal on governorship election disputes. Of course, one, let's go to Benue State, where the court held that this issue of certificate forgery was a pre-election matter. And if the suit touches on the basic qualification of the candidate who is now an office holder, should be a limitation of when such a suit should be brought before the court. Now, my question is this: how much of confidence do you think, with recent trends and happenings, do people still have on the judiciary, given the fact that right now it's a situation of the vote of the people on one side and then the judiciary on the other side making the decisions?
You see, the law is not emotional, to be honest. The law pays zero attention to our feelings. There are guidelines, there are procedures, and the law follows procedures. The law follows guidelines, and the law follows precedents, judicial precedents. So people have the right to air their opinion. People have their constitutional guaranteed right to say their mind as to what they believe or what they feel they are seeing within the courts or the judiciary. But the court still reserves its right also to, adjudicate on issues and matters. So that's what I would say on that.
Now, of course, before I let you go, let's also talk about another pivotal issue where the Court of Appeal gave the appellant the leeway to get involved in how the candidate of another party emerged. Now, we are asked a number of judgments that suggest the emergence of the candidate in the reserved, of course, business of the party. What some are saying is this issue at hand in Plateau State is actually more of a party issue than, even a national issue. I mean, are there no provisions within the law that sort of allows for issues at, party level not to sort of snowball into what we're seeing right now?
You are right. To be honest, pre-election matter or party matter is a pre-election matter and shouldn't be brought into election matter. and I'm relying on Wellington against PDP Supreme Court decision, part 1893. So the Supreme Court was clear when it stated that pre-election matter is statute barred. That means you cannot bring pre-election matter as election or under election petition. Although there are exceptions to all these rules, that's why I say it is a dicey situation. Until we see the CCC of the judgment, we would know where the Court of Appeal is coming from. But as it is, whatever the court says is the law, until the Supreme Court says otherwise. But party issue or nomination, anything that has to do with party, strictly, from my understanding of the provision of the Electoral Act, borders on pre-election issues. So when you are bringing it in as election petition issue, I believe it should be statute back. You shouldn't bring it up. So any court that is hearing such matter, I feel doesn't really have the requisite jurisdiction to hear them.
All right. Thank you so much for your time, Valerian.
Thank you very much.